Several U.S. senators filed an amicus, or a friend of the court brief, in the case New York State Rifle and Pistol Association versus the City of New York. Now, the senators make some interesting points, some of them good, some not so good. However, there's a lot we can learn, not only about the constitutional issue, but about the state of our political discourse. So we'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution and teach the rising generation to be free. I'm glad you could join me today. As always, head over to the website, constitutionstudy.com, so you can find out everything I'm working on. You can see how you can stand up for your own rights. Watch the video, listen to the audio, read the web articles, see where I'm speaking, ask a question, even ask me to come speak at one of your events. It's all there. I want to thank everybody that helps share these videos, the audio, all the work that we're doing, because I think it's a really important point. This isn't just for us to use, but it's material I create so that we can share it so others can see how important it is to learn about the Constitution. In fact, not just about the Constitution, but how our government is supposed to work. And speaking about how our government is supposed to work, let's take a look at this amicus brief. Quote, "The judiciary was not intended to settle hypothetical disagreements. The framers designed Article 3 courts to adjudicate actual controversies brought by plaintiffs who suffer real-world harm. Now, it has long been legal practice that a plaintiff must show actual harm before they can sue." Now, this is not based on anything I've read in the Constitution, though I do find some logic behind it. You don't want people flooding the court with suits simply because they think maybe, possibly, there might be a problem, they might get harmed. So there's a reason for this, and as they go on, the amici go on, the rationale for this long-settled principle is simple. The court is not a legislature. See, while it's not the role of the courts to create, execute, or establish law, the question remains, do my rights have to be actually violated before I can petition my government for redress of that grievance? Now, the one point these senators raise that I believe is valid, if the respondents have already agreed to the petitioner's demands, why is the case still going forward? In other words, now that the New York State Rifle and Pistol Association has won, why has the case not been dropped? Well, the first reason the case has not been dropped is the respondents have not agreed to the petitioner's demands. You see, New York City did not rescind the law in question. They only loosened some of its restrictions. Apparently, they hope that keeping the rest of their draconian gun control laws out from court review will protect them from being found unconstitutional. The second reason, in my opinion, though, is based on how we've corrupted the government created by the Constitution. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. What the senators call Article 3 courts are the courts created by Article 3 of the Constitution. But somewhere along the line, we've morphed this judicial power from deciding cases into the power to overturn the legislative process. You see, today's laws aren't really laws until the court has blessed them. If the court finds against a law, even if it's entirely constitutional, then effectively the law is of no effect. Now, is this the way the system was designed? Well, let's ask Alexander Hamilton. See, he wrote in Federalist 78, "The interpretation of the laws is a proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents." So the purpose of the court, yes, it's to interpret the law. I kind of dislike the way we use that word, but it's there to look at the laws, all the laws, and determine the proper opinion for a case. It's to look at the Constitution and the laws from the legislature and say, if there's a problem, well, the Constitution must win. The voice of the people, as recorded, must win. Now, Alexander Hamilton goes on. Nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature declared in its statute stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decision by the fundamental laws rather than by those which are not fundamental. In other words, the judges are not supposed to have this veto power that we've given them. The role of the judiciary is not to be superior to the legislature, but to place the will of the people as expressed in the Constitution above them both. But that's not what we have nowadays. Nowadays, we have courts that basically veto legislation. Look how often state and even federal laws are put on hold until the courts have a chance to review them. Now, if the courts have this power, what's to keep the courts from substituting their will to that of the actual language of the law? Well, we go back to Article 3, Section 1. The judges of both of the Supreme and inferior courts shall hold their offices during good behavior. See, since the people that we have chosen to act in our name have abdicated their responsibility to punish the members of the judiciary who do not behave well, there's effectively no check on the unabridged judge or justice. See, therefore, the law effectively has no meaning except what the courts have placed on it. We've turned them into kings and queens. See, this is the reason the New York State Rifle and Pistol Association has continued the case, or at least in my opinion. See, they want the final opinion, the final word from the high priests and priestesses in black robes that we call the Supreme Court. They don't want to stop because they want to get the answer whether or not the court's going to veto it. Now, if the senators had stopped with the question of should a case continue when the desired outcome of the plaintiffs has been reached, I would have supported their position. However, that's not what happened. It can be tempting for judges to confuse their own preferences with the requirements of the law and to legislate political outcomes from the bench. But a judge is not a knight errant roaming at will in pursuit of his own ideals of beauty or of goodness. Now, even for a group of senators, this is hypocrisy on a whole nother level. See, many of these same people are on record not only attempting to persuade the court to address perceived issues with current law for them, but establishing a political litmus test for which the high court nominee that comes before them must follow if they want to be confirmed. Now they're concerned that the court might attempt to legislate political outcomes, while at the same time they're requiring the nominees to effectively swear allegiance to their political outcomes in order to win their vote. These senators complain about multi-million-dollar advertising campaigns to shape the court's composition, while they themselves are attempting to influence the court with the power of their offices. Not to mention the millions spent in recent years trying to shape the court by cherry-picking justices, not based on the knowledge of the Constitution they will swear to support, but by their fealty to a political party's platform. They ignore the billions spent by governments, private citizens, and organizations to influence the court's opinions and establish a precedent to protect their favorite opinion with little, if any, regard for the law or for the Constitution. See, now, when the court is expected it might find against some ridiculous or tyrannical gun control laws in a rabidly anti-gun city, now these senators are concerned. Now they're concerned the court might put something before their preference to see guns out of the hands of law-abiding Americans and the effective destruction of our rights protected by the Second Amendment to the Constitution. Worse, they now threaten to abuse their power as U.S. senators to get what they want. Amici share with the court a strong interest in the preservation of the separation of powers that sustains our constitutional form of government. See, the reason for filing this brief, at least according to the senators, the amici, is an interest in preserving the separation of powers. Yet I find this rather hard to swallow when we read the end of the brief. The Supreme Court is not well, and the people know it. Perhaps the court can heal itself before the public demands it be restructured in order to reduce the influence of politics, particularly on the urgent issue of gun control. A nation desperately needs it to heal. See, these senators have listed several issues with how the court is handling the case, And as we've discussed, these issues come primarily from how we've let the federal government ignore the Constitution and twist it to say collect political power within the federal government, particularly within the judiciary. And what is the solution these senators propose? Threaten the court with restructuring if they do not bend to their political wills. See, the plan for restructuring that has been proposed is to increase the size of the Supreme Court. Now, would this increase happen immediately? Oh, of course not. No, the politicians proposing restructuring the court have stated they will wait until someone from their party becomes president. That way they will get nominees of their own political party. Does that sound like making the court less political to you? No, this is court packing, which has been a tool of politicians since John Adams all the way back in 1801. In every case, this was meant to make sure the court would support the ideas of a particular political party, not to return them to their constitutionally authorized role. Sadly, this is all too common a situation. Once again, we see people in government with a real issue to discuss turn instead to naked power grabs to get their way. And make no mistake, this is a naked power grab. While this time the power appears to be targeted at the judiciary, it's really targeted directly at the Constitution itself. Now, is the Supreme Court not well? Well, I think so. As I've documented time and time again here in the Constitution Study, I find it hard to believe that 9 of the supposedly best legal minds in the nation cannot read and comprehend the simple English of the Constitution. A Constitution, by the way, they swore or affirmed to uphold and to treat as the supreme law of the land. However, if the court is sick, the cure proposed by the senators is worse than the disease. Remember, several of the grievances our founding fathers listed in the Declaration of Independence include abuses by British courts and the influence the king had over their decisions. Is the influence of a group of senators any less abhorrent than the influence of a king? If we were once willing to fight a war, in part because of the inability to receive justice due to a political influence, will we stand for it now? Now, if you are a citizen of the states of Rhode Island, Hawaii, Connecticut, Illinois, or New York, you should ask yourself a simple question. Is this the type of representation you want? Is this who you are? Now, you may support gun control, and you may not want the court to find the New York City law unconstitutional. But let me ask you, are you a bully? See, if you can threaten the court to get your way, what does it stop someone else from doing it to get theirs? If you want the court packed to protect gun control laws, would you be willing to have it packed to say, overturn them? See, if you set the precedent that your senators can stomp their feet and threaten the courts to get their way, then you, the people of these states, are nothing more than bullies. And the rest of the country should treat you accordingly. Now, that's a pretty bad tasting medicine, and I'm sorry there's no sugar to make it go down easier. If your representatives, if the people you elect, are willing to make the court an offer it cannot refuse, you should not be surprised if you wake up one morning with a horse head in your bed. And if you don't recognize that metaphor, I suggest you watch The Godfather. That's right. What we see here is a naked power grab. We see bullies from the Senate trying to force the court to make a politically based decision because they don't want gun control laws overturned. Again, support them or not, is that the way you want your country run? Because today, senators may be bullying for gun control. Who knows what they'll be bullying for tomorrow? And that's right, if you live in those states, this is your fault. These people represent you. You elected them. If this is what you want, then you're nothing more than bullies. And it's about time the rest of the states start treating you like that. Now, personally, I'd like not to get into a shooting war over this problem, but it's about time we stopped acting like this stuff doesn't matter. Like the idea of senators bullying courts is no big deal. Like the idea of courts ignoring the Constitution and enforcing their will on the people is no big deal. Like the idea of people we elect to represent us not doing their job to rein in, to punish bad behaving justices is not a big deal. See, the problem is we've been sinking by small measures. We're about to go under. Well, at least in some ways. If a group of senators can destroy this right, can bully a court into taking away your right to protect yourself with the best tools possible, what's to prevent them from bullying a court to saying you don't have the right to speak freely? You don't have the right to be safe in your home. You don't have the right to publish stuff on the internet. You don't have the right to do anything they don't want you to do. Don't believe me? Have you watched the news? There are senators out there who don't want you to have the right to choose your own health insurance. They don't want you to have the right to do things the way you want. They want to tell you how many types of underarm deodorant should be for sale in the stores. They want to tell you what you should and shouldn't be able to do with your life. They want to tell you what you should and shouldn't be able to sell in your stores. They want to control your life. And if we let them bully the court here, what's to prevent them from bullying the court tomorrow? So I hope that got your attention. And if you're from one of those states, well, that was a pretty bitter pill to swallow, and I hope you choke on it. It's not that I wish you evil, but until we start recognizing what's being done in our name, what our agents are doing, and the destruction they're causing, we won't bother to rein them in. See, it's not good enough to simply sit back and say, oh, we'll let them take care of it. We've let them loose, and until we start reining them in, it's only going to get worse and worse and worse. Which is why I do this. It's why I spend the time reading these amicus briefs and court opinions and legislation and writing videos and articles. It's why I do this, to help all of us start thinking about these things, not as some abstract action taken by a bunch of yahoos in Washington, D.C., but realizing those yahoos represent you and me and every other American in this nation. So it's time that we start taking our hired employees to task. And it's time we start reining them in. And the citizens of Rhode Island, Hawaii, Connecticut, Illinois, New York, if you won't, then you're asking for trouble. Because pretty soon, the other 45 states are going to have enough of this. And they're going to turn around and start treating you like the bullies your representatives are showing you to be. So head over to the website, constitutionstudy.com. I bet you some people are not going to be real happy with the conclusions that I've drawn here. But I think it's important we recognize we're letting our country get away from us. We're letting our rights bleed away, and we're sitting back and hoping somebody else will do something about it. Well, it's time that we stop waiting for somebody and we start doing something ourselves. So again, head to the website, read some of the material, comment, ask questions. I love questions. Hey, I would love it if you'd have me come out and speak to one of your groups. Most of all, read and study the Constitution for yourself. So when you see stuff like this happens, you at least know something is wrong and you can find out what the problem is. And I hope you'll join me again the next time when we get together here at the Constitution Study.
Came from a long through line of everyday